Order. The clerk will now proceed to read the orders of the day.
Item 1, Stamp Duties Amendment Bill, second reading.
Deputy Prime Minister and Minister for Finance.
Madam Deputy Speaker, on behalf of the Deputy Prime Minister and Minister for Finance, I beg to move that the bill be now read a second time. The Stamp Duties Amendment Bill 2022 introduces the additional conveyance duties for trusts or ACD trusts and imposes stamp duty in relation to the renunciation of interest by a beneficial owner in residential property that is held on a trust. If passed by Parliament, the amendments in the bill will take effect on 10 of May 2022, that is, one day after the first reading of the bill. As the bill amendments are market sensitive, this approach brings the bill into effect the day after its introduction. Before I go through the key amendments in the bill, let me explain the rationale for the changes. Today, residential properties can be acquired directly or via equity interests, including unlisted shares in property holding entities, or PHEs. These refer to entities whose primary tangible assets are residential properties in Singapore. Direct acquisitions of residential property are subject to buyer's stamp duty, or BSD, and, where applicable, additional buyer's stamp duty, or ABSD. Acquisitions of unlisted shares in PHEs are subject to share duty of 0.2% based on the purchase price or the value of the shares. Such acquisitions may also be subject to ACD if the acquirer is a significant owner of the PHE or becomes one after the acquisition. A significant owner is a person who beneficially owns at least 50% of the equity interest or voting power in the PHE. ACD was introduced in 2017 to address the stamp duty rate differential that previously existed between the direct acquisition or disposal of residential properties and the acquisition or disposal of equity interests in PHEs. ABSD and ACD thus operate together to promote a stable and sustainable residential property market in Singapore. Madam, previously, when residential property was transferred into a living trust with no identifiable beneficial owner of the property at the time of transfer, ABSD did not apply. As trusts are complex instruments and serve diverse purposes, the government carefully studied the issue before deciding on how transfers of residential property into trusts will be treated. We then introduced additional buyer's stamp duty for trusts or ABSD trusts on 8th of May, which took effect on 9th of May 2022. ACD trusts follows from the introduction of ABSD trusts. With ACD trusts, ACD may apply when equity interests in a PHE are transferred into a living trust, regardless of whether there is an identifiable beneficial owner of those interests at the time of transfer. These changes ensure similar stamp duty treatment for transfers of residential property or equity interests in a PHE, whether acquired directly or through a trust. If an institution of a public character, or IPC, is the sole beneficial owner of the residential property or equity interest in a PHE transferred into the trust, among other conditions, the IPC can apply for remission of ABSD trusts or ACD trusts. Today, donations of immovable property or unlisted shares of two IPCs qualify for stamp duty remission. Let me elaborate on ACD trusts, which is primarily provided for under Clause 5 of the bill. To determine whether ACD trust applies to the acquisition of equity interest in the PHE that are to be held on a trust for beneficiaries who are not identifiable beneficial owners. We will consider the equity interests in the PHE that are to be held by the trustee of the trust for those beneficiaries. This consideration is only of the portion of interest to be held on trust for those beneficiaries. For example, if the trustee is to hold 10% equity interest in the PHE for identifiable beneficial owners and another 5% for other beneficiaries who are not identifiable beneficial owners, only the 5% equity interest will be considered to be held by the trustee for the purpose of determining whether ACD trust applies. ACD trust will apply in such a case only if the trustee is a significant owner with at least 50% equity interest or voting power in the PHE, or becomes one after the acquisition. In determining the trustee's significant ownership status, the equity interests that are beneficially owned by the trustee's associates will be treated as beneficially owned by the trustee. A treatment for associates already exists in the ACD regime to cover arrangements under which individual buyers act in concert to purchase equity interests, with the objective of avoiding ACD. Examples of associates include parents, children, spouses, and associated companies. In assessing whether an identifiable beneficial owner of equity interest in the PHE is a significant owner of the PHE, the interests beneficially owned by the beneficial owner and the beneficial owner's associates will be considered. In the instance where a trustee holds equity interest for a beneficiary who is not an identifiable beneficial owner of those interests at the time of their transfer into the trust, such a beneficiary is considered an associate of the trustee in determining whether the trustee is a significant owner of the PHE. Now, this definition of associates will be provided for in subsidiary legislation. If ACD trust applies, the trustee will be liable to pay ACD trust at the prevailing ACD rates of up to 44% for buyers, comprising 40% ABSD and up to 4% BSD. ACD trust may also apply if the trustee, being a significant owner of a PHE, disposes of the trustee's equity interests that were held on trust for a beneficiary who is not an identifiable beneficial owner. If the trustee disposes of the equity interests within 3 years after acquiring them, the trustee will be liable to pay ACD at the prevailing ACD rate of 12% for sellers, equivalent to the highest seller's stamp duty or SSD rate. In addition, where the trustee transfers equity interests to a beneficiary of the trust who was not an identifiable beneficial owner of those interests at the time they were transferred into the trust, the beneficiary will be liable to pay the prevailing ACD for buyers if the beneficiary is a significant owner or becomes one after the transfer. Clause 3 of the bill provides for this. Next, Clause 4 of the bill introduces a new Section 22C, which imposes a statutory duty on the original beneficial owner of a trust residential property who renounces his or her interest in the property, such that this interest reverts to the settler of the trust. The original beneficial owner is one who beneficially owns the property at the time it is transferred into the trust. The original beneficial owner must give a written notice of the renunciation to the settler and to the Commissioner of Stamp Duties within a specified period. If he or she fails to do so, and the Commissioner becomes aware of this, for example, through IRAS's regular audit, the Commissioner may give the notice to the original beneficial owner and the settler instead. For his or her failure to give notice, the original beneficial owner will be liable on conviction to a fine not exceeding $1,000. The notice, whether given by the original beneficial owner or the Commissioner, will be chargeable with stamp duty. Specifically, the settler will be liable to pay BSD and, where applicable, ABSD. If the interest in the trust residential property is renounced within 3 years after the original beneficial owner first has beneficial ownership of the interest, the original beneficial owner will also be liable to pay SST. For any duty paid late or not paid, the original beneficial owner or the settler will have to pay a penalty of up to 4 times the duty payable, which is the penalty under the current Stamp Duties Act. This treatment for the renunciation of interest by an original beneficial owner will ensure that where the beneficial ownership of a trust residential property reverts to the settler would have to pay stamp duty, similar to if he or she had acquired the property directly. Clauses 8 and 9 make transitional provisions to modify the application of the bill to matters occurring between 10th May and the date the amending act is published in the Gazette. On that, Madam Deputy Speaker, I beg to move.